students, welcome to Tarunayas. Today we will be discussing daily current affairs of 10th of November 2022. So let's start with the first news of the day. The first news is about the discovery of a new crab species. So this is the new crab species that has been discovered from the state of Karnataka. So you can look at the feet are purple in color and the body is pale white. All right. So this species, it has been discovered from the estuarine at the mangroves of the Parangipettai, which is near the Vellar river in Cuddalore district of Karnataka. The species, it has been renamed as Pseudohelis anomalii. It is named after the mountain. And this is the first ever record of this genus to be discovered in this area. And Pseudohelis, which is collected from the high intertidal areas in front of the CAS. So far, only two species, that is Pseudohelis subquadrata and Pseudohelis laterali, have been confirmed within this genus. And this is the new species which has been named as Pseudohelis anomalii. So there is no need to remember the name, the scientific name. However, the question could be asked based on the previous year questions that a new crab species were discovered from the Cuddalore district, or what is the specification of this species and etc. Let's discuss a brief about the estuarine and this intertidal areas. So estuarine means where the river meets with sea. However, due to the presence of hard rocks, the river flow is not able to deposit. There is no much deposition here, thus delta is not formed. So wherever there is a presence of alternative soft and hard rocks, for example the Deccan area where there is a huge presence of the hard rocks, the river do not form delta, instead they form what is called as estuarine. And these estuarines, they are rich in nutrients and thus they form the habitat for many of the marine animals, including the crab species, the fishes and etc., the prawns. And these intertidal area means where the two tides meet. For example, when we talk about the high tide, let's say this is the baseline. First let me so these intertidal areas means where the two tides meet, right? So now what happens, let me consider that this is the baseline of the coastal area, and when there is a high tide in the sea, then the water flows up to this level. So water will flow up to this level, and when there is a low tide, so water will flow up to this level, let's say till the baseline. Now this portion, that is the limit of the high tide and the low tide, this is known as the intertidal area. And this intertidal area is rich in nutrients, and hence this is habitat for many of the marine and aquatic animals, flora and fauna, including both. Even the plant species, they thrive here in intertidal zone. Some algae and some mangroves are there. In fact, mangroves are located majorly in the intertidal areas, and we have what we called as these corals. So corals are also found near these areas because of the high nutrient content which is present in the intertidal zones. Now the next news of the day is about the age of consent. Now we know that in India, the age of marriage, the legal age of marriage is fixed. For girls, it is the 18 years of age. However, there are still cases of the child marriage, and for boys, it is 21 years of age. Now, what happens? According to the legal definition, any person, any individual who is below the age of 18 years is considered as a minor or a child. However, the definition of a child is different from country to country. In India, it is considered as 18. it is considered as 18. Even according to the POCSO law, even according to the POCSO Act, it is considered as 18. A minor is considered below 18 years of age, and this is the limit. And above, and all those who are above the 18 years of age and are of 18 years of age, they are eligible. They are considered as eligible voters in India. However, the Dharwad Bench of the Karnataka High Court has talked about that there should be a differentiation between the age of consent and the age of marriage. Now, what do we mean by this age of consent? Now, what happens under various circumstances that there have been cases where the parents of an adolescent child, that means an individual below the 18 years of age, have registered cases in the court regarding the rape. However, the case was not of rape, but rather it was the case of the sexual consent. Now, what happens according to the bench, the age at which a person is eligible to give sexual consent and the age at which a person is eligible to get married are both different. Both should be different, and what the court is trying to say, that there is a need to look into this matter, because there has been incidents where the POCSO Act and the Juvenile Act has been misused by many of the parents, and in many cases they have been misused against the parties, against the concerned party. So let's look at that how the age in India has been defined. We know that the age of consent has seen a progression in India from the 10 years of age to 12 years of age, and to 16, and then to 18 years of age. We have seen the progression when it comes to the girls. So age of consent bill that was passed during the British colonial rule in 1891, it increased the age of consent to 12 years. That means a girl who is 12 years of age could got married during pre-independence time. Right, during pre-independence time. So if you remember that there was a PYQ, that means the previous year, in previous year the UPSC has also asked the question regarding the Rakhma Bai case, which is one of the most Rakhma Bai case, which is one of the most highlighted case when it comes to the age of consent. So this was the death of a 10-year-old age of consent. So what happened in the Rakhma Bai case? A 10-year-old girl who had got married to a 30-year-old man had died on the first night itself. So this was the Rakhma Bai case, and this is the question which was asked in the UPSC prelims. So age of consent becomes of importance because the government is considering to increase the age of marriage to 21 years of age for the girl child. Right, so there have been experts' opinion divided on both sides, whether it should be increased or not, or if not, then why, and whether if yes, it should be increased, then why. So let's look at the provisions. After the amendment in the IPC, we know that in 1860 the Indian Penal Code were drafted after the TB Macaulay Committee. In 1860, the IPC, the Indian Penal Code, was drafted, and it had considered 14 years of age as the age of consent. However, in the present time, it has increased to 18 years of age. After the passage of the Child Marriage Restraint Act, the age of consent was increased to 14 years of age. And presently, the age of consent and the age under the various sections of the IPC, except for the section 2 of the section 375 of the IPC. We will talk in detail about the section 375 of the IPC, which talks about the rape, and it gives exception to the rape cases where a girl who is below the 18 years of age, however she is married to a person. So this is one exception which is given in the section 375 of the Indian Penal Code. So these are this is the age of consent in India, the age of marriage in India, which is 18 years of age. However, the age of consent as well as the age of marriage in India are same. The court is of the opinion that the age of consent and the age of marriage should be different, because according one of the views of the court when it was dealing with one of the cases, that there are experimental activities that goes on between the adults, I mean between the adolescents, and we cannot consider it as a case of sexual excesses or rape. So this is the opinion of the Karnataka High Court. So what is the news that on November 4th, the Dharwad Bench of the Karnataka High Court had dismissed one case which was filed under the Protection of Children from the Sexual Offences Act of 2012, said the Law Commission of India would have to rethink the age criteria and take into consideration the ground realities of the country. So under the POCSO Act of 2011, under the several provision of the IPC, and whoever commits a penetrative sexual assault on a child can be imprisoned for a term not less than 7 years. Not less than 7 years. So the age of consent and the age of marriage has become a highlighted issue in our country. Even if the girl is 16 years, so the court had highlighted a 16 years old girl who had is considered a child, and her consent does not matter, and a sexual act is considered as rape. So there has been several instances in the past when the courts had quashed the criminal proceedings of rape to suit one or the other party, and the offender had booked the cases under section 366 of the IPC, section 6 of the POCSO Act, section 9 of the Prohibition of Child Marriage Act of 2006. So why the law is being misused, and if yes, then how it is being misused? Now what happened? The court had observed that there are disgruntled parents, and they want to break the relationship between the two adolescents. So therefore they uses these legal provisions to commit this act, or to give to break the relationship between the two adolescents. So in the 2019 study, and this can be quoted as one of the sociological case study for the sociology students. So in 2019, a study was conducted that why girls they run away to marry. There have been many instances where the girls they elope to get married for the purpose of getting married. Adolescent realities and the social legal responses, they have made a case that age of consent should be lower than the age of marriage. So this is what the opinion of the experts are, that the age of marriage, the age at which a girl get married or a boy get married, to be gender neutral, it should be different from the age of consent. That means when they are behaviorally and psychologically mature enough to give consent for the sexual activities. The study had noted that the couple elopes, they fearing opposition from the parents, which results into a situation where one of the families or any of the families, they file case with the police, and this case is then registered as rape case, because any penetrative sexual activity with a girl below the age of 18 years is considered as rape according to the IPC, except for the exception 2, which is given in the section 375 of Indian Penal Code. The next news of the day is about the EPFO scheme, which is Employment's Provident Fund Organization of India. Now, why this pension scheme has been in news? So, if you have been following current affairs, then yes, there have been demand by the pensioners to increase their pension. And now, what happens? The Supreme Court has upheld the Employees Pensions Amendment Scheme of 2014 of the EPFO as legal and valid. Now, this was the legal and valid while reading down certain provisions. The source of the news is the Hindu, and let's see what are the main provisions of the Employment Provident Fund and Miscellaneous Provisions Act of 1952, which did not originally provide for any pension scheme. So there were, according to this Act of 1952, there was no pension scheme. In 1995, through an amendment, a scheme was formulated for the employees' pension. So the employees' pension, it started to be given since the year 1995, and before that there was no pension as per the EPFO, right? According to the EPFO provision, we are not talking about the pensions which is given to the other government employees. We are talking about the EPFO, for which the eligibility criteria is any person who earns income up to 15,000 rupees per month, right? Below 15,000 rupees is the limit in case of the EPFO. So the scheme, which is administered by the EPFO, it aims to provide employees with pension after the age of 58 years of age, right? After the age of 58. So what are the main points that may be important from the prelims perspective, and you can quote these data and this scheme in your mains answer. In Indian society, social empowerment and empowering old age. So these could be the topics where you can use this news, you can use the data. So now what happens in the EPFO? Both the employee and the employer. Employee means the one who is working, and the employer means the one who recruits. So they have to contribute 12% of their employees' basic salary and dearness allowance to the EPF. This dearness allowance is given for the inflation purpose, right? Now what happens? The basic salary and the DA of a person, its 12% has to be contributed by the employer and the employee, right? So let's say if the salary is 15,000 rupees, right? So if the basic pay is 15,000 rupees including the DA, now what happens? 12% of this will be contributed by the person who is recruiting, that is the employer, and the person who is working. So both of them, they are going to contribute it to their EPFO fund, that is the employment EPFO fund. And after the age of 58 years, it will be then given to the person as a monthly pension, right? So what happens? The employee's entire part goes to EPF, while the 12% contribution which is made by the employer is split. Now suppose if I am the employee, right? I am going to contribute 12% of my salary to the EPFO fund. Now this 12% will go exactly as the EPFO fund. However, the employer contribution, the one who has recruited me to the job, its contribution is going to split. It's going to split as 3.67% of the contribution to the fund and 8.33% contribution to the EPS, which is employment pension scheme. So there is a pension fund and there is a pension scheme. So the employer's contribution is going to split in the ratio of 3:67 to 8.33, right? Apart from this, the government of India contributes 1.16% as well for an employee's pension. Employees do not contribute to the pension scheme. So employees, they do not contribute to the pension scheme. Their contribution goes to the fund. Their contribution, where does my contribution goes? My contribution, if I am a worker, it will go to the fund. But the contribution given by the employer will get split into two parts, and 1.16% will be contributed by the government of India towards the pension scheme, right? So at that point of time, the maximum pensionable salary, the maximum salary at which you are eligible to get pension was rupees 5,000 per month. Then this was later revised to 6,500 rupees per month. In 2014, in the employees pension scheme, an amendment was made and the pensionable salary, it was capped at rupees 15,000 per month. So currently, the maximum salary at which the person becomes eligible for pension is rupees 15,000 per month. All right. Now, it gave all EPS members on September 1st, 2014 six months to opt for the amended scheme. Now, if the scheme has got amended, now I have to opt for the scheme. As a worker, I am going to file my papers and fulfill all the paperwork that are needed to be fulfilled for me to be eligible for the pension scheme. So September 1, 2014 was the limit. However, the amendment required such members with actual salaries over rupees 15,000 a month to contribute an additional 1.16% of their salary exceeding rupees 15,000 a month towards the pension fund. Right. So this was one condition, that such members to contribute an additional, so members who are going to become eligible or who are going to opt for the new pension scheme, that is the amended pension scheme of the year 2014, they were supposed to contribute 1.16% to the pension fund, and this 1.16% was to be contributed by the government of India. Now the court struck down this requirement in the 2014 amendment that employees who go beyond the salary threshold should contribute monthly to the pension scheme at the rate of 1.16% of their family. The court also held, now the court has struck down this provision. The court has struck down this provision. Now the court has also held that the employees who are eligible to join the pension scheme but they were unable to do so. That means, suppose due to certain circumstances I become unable to do it. There are two things, whether I am eligible to do so or I am unable to do so. So the court is of the opinion that those who were eligible but they were unable to do so, they did not exercise their option by the deadline, can do so within next 4 months. So that means they are given another chance that within next 4 months they can do so. Right. So this was the court's ruling that has come recently. The next news of the day is about the Infrastructure Project Development Fund. Right. Infrastructure Project Development Fund. We know that for any nation, infrastructure is of utmost importance, and infrastructure does not only mean erecting the concrete building. It's a word which encompasses infrastructure in all the sectors of the economy, in all the sectors of the social economy that contributes to the prosperity and the growth of the nation. So starting with the social infrastructure, so we have educational infrastructure, we have hospitals, that is medical infrastructure. So these two infrastructure, that is educational institutions and hospitals, the infrastructure should be accessible and affordable to all. So, and Government of India runs various schemes to make education Government of India runs various schemes in order to make the education and medical facilities available and affordable to all. So this was about the social infrastructure, right? Now we have digital infrastructure too. That means post 2014, when the digital mission in India it was launched, we have to have a digital infrastructure that caters to the need of the future generation as well as the progressing present generation. Now what happens, apart from these two infrastructure, we do have the physical infrastructure as well, which includes logistics. Now logistics is a broad term which encompasses not only the transport but also the cold storage, the management, the packaging, etc., etc. Then we have got roads, we have got railways, we have got airports. Now these modes of transport, these various modes of transport, they seek to interlink and interconnect the country wherever possible, either by road, by railway, or by airways. Then we have got inland waterways as well. For example, the Ro-Ro ferry, etc. Then we have got new schemes by the name Parvatmala. So Government of India has various schemes going on, such as we have got Bharatmala, then we have Sagarmala, and also the new scheme we have got Parvatmala. So all these schemes, they are meant to enhance the infrastructure. The Gati Shakti scheme, the national infrastructure pipeline, the national monetization pipeline. So all these efforts of the government of India, they are to enhance the infrastructure. Now we have new scheme by the name India Infrastructure Project Development Fund. Now let's look at what this scheme is about. Now, the Department of Economic Affairs in the Ministry of Finance has notified this IIPDF scheme, which is for the financial support for the project development expenses of the public private partnership project, that is the PPP projects. What are the main points? The scheme, it was set up in the year 2007. It is a central sector scheme. That means it is completely funded by the union government, and it has outlay of rupees 150 crore for a period of 3 years, that is starting from the year 2022 to the year 2025. Now these are counted as the financial year, that is the financial year of 2022 to 23 and the financial year of 2024 to 2025. It is available to the sponsoring authorities for the PPP project for meeting the project's development cost. Sometimes what happens, these PPP projects, though they look very lucrative, however, they get stalled due to various reasons. Sometimes there are environmental clearance reasons, sometimes there are fund reasons, etc. Majorly, there are the reasons related with the funding which stalls a project. So therefore, the government of India has come up with this scheme called Project Development Fund Scheme. Now, it is necessary for the sponsoring authority to create and empower a PP cell to undertake PPP project development activities and also address the larger policy and regulatory issue. It aimed to provide financial support for the quality project and development activities. The IIPDF will also contribute to 75% of the project development expenses to the sponsoring authority as an interest-free loan. That means there will be no interest on the loan that is given, which is 75% of the project development expenses. And the balance 25% will be co-sponsored by the sponsoring authority. The next news of the day is about the new TV guidelines. So the Union Cabinet has approved the new guidelines for uplinking and downlinking of the TV channels, under which all stations holding permissions, that means those who have the permission except for the foreign channels and where it may not be feasible, for example the sports channels, they have to compulsorily broadcast for at least 30 minutes every day a content on the issue of the national importance, right? So these are the new guidelines for the TV channels, that those channels who are eligible for 30 minutes, they have to broadcast any content which is socially relevant, socially relevant. So the provision, it has been introduced according to the Union Cabinet, because the airways or the frequencies, they are public good and their use has to be in the best possible interest of the society. The consolidated guidelines have exempted certain channels related to the sports because where it will not be feasible to broadcast such contents. The new guidelines, according to the minister, would ease the issue of permission to the companies and the LLP, which is limited liability partnership firms, which have been allowed for the first time. The requirement to seek the permission has also been done away with. So these are the new guidelines. The first one and the most important one is the broadcasting of a socially relevant content for 30 minutes on their channels, those channels which are eligible for the guidelines. The next news of the day is about the Pashmina shawls. Now, why Pashmina is a very famous shawl from the Union Territory of Jammu and Kashmir. Now, why this has been in news recently? The traders of this universally prized Pashmina shawls, they have been complaining about the obsolete testing methods which are used by the custom authorities, who have flagged the presence of the shahatus guard hair. Now, it is to be noticed that the shahatus and the pashmina, they are two different things. The pashmina shawl, the thread for the pashmina shawl is obtained from this Changthang god, who are reared particularly in the area of Ladakh and the Tibetan Changthang plateau. So Changthang is different, and Shahatu's hair is obtained from the Tibetan antelope by the name Chiru. So Changthang goat and Chiru are two different animals. So the custom authorities have flagged the presence of the Shahatu's guard hair. Now, why this is of concern is because Pashmina shawls of Union Territory of Jammu and Kashmir, they are exported, and they are also have been given the GI tag. Now, any product which is given the GI tag should be of the utmost purity. So if they are exported and there is a presence of the hair from the another goat, it is not going to, it will not qualify the purity standards, all right, and the standards for which the GI tag product is known, right. So that is the reason why this is of a concern. And recently it has been observed that the rate of the Pashmina shawls have declined. There used to be somewhere 700 crore annually. This has declined to 100 crores only. The lot which goes, this is not just one shawl, right? Of course. The point is, the Pashmina is obtained from a breed of the mountain goat, which is found at the Changthang plateau in Tibet and the parts of Ladakh. This is not video. And the Shahatus is obtained from Tibetan antelope by the name Chiru, which are species that lives mainly in the northern parts of the Changthang plateau. Let's look at the status of the Chiru. The IUCN status of the Chiru is near threatened. Wildlife Protection Act has given it is under Schedule 1, and for the site it is in Appendix 1, right. So you can look at the picture of these two goats. This is the Changthang goat. So if you look at Changthang and Chiru, they look very different from each other. So, and this is an antelope. Chiru is an antelope. The recognizing or the distinguishing feature of the antelope is their antelopes, that they're standing, and there are two standing antelopes. That is the horn, right? Horn. And if you look at the Changthang goat, then the horn are little, they are curved, and they are not standing. They're a bit they're laid on the head of the Changthang goat. So this is Changthang, and this is Chiru. So that's it for today. Thank you so much for watching Tarun IAS. Have a nice day.